So, appreciating that it is now the hour of 5 and we have a quorum. Is that committee member McMillan I see now too? Oh, great. Okay, welcome committee member. Welcome committee member McMillan. So, seeing that we have everyone, I will now call this meeting to order. I'll start with the land acknowledgement statement and acknowledge with respect the history, spirituality, and culture of the Anishinaabeg, the people of the Three Fires known as Ojibwe, Odawa, and Potawatomi Nation, who have inhabited this land from time immemorial, and further give thanks to the Chippewas of Saugeen and the Chippewas of Nawash, now known as the Saugeen Ojibwe Nation, as the traditional keepers of this land. We also recognize the Métis and Inuit whose ancestors shared this land and these waters. May we all, as treaty people, live with respect on this land and live in peace and friendship with all its diverse peoples. So I will now read the recommendation that the agenda be approved as presented. Looking for a mover and a seconder. Moved by committee member Coburn and seconded by committee member Glenn. All those in favor? That motion is carried. I'll ask for a disclosure of pecuniary interest to declare. Seeing none, I'll let the committee members know that if one were to arise in the process or in the middle of the meeting, you can feel free to declare an interest at that time. So looking at the minutes of the previous meetings, I'll read the recommendation that the minutes of the Committee of Adjustment meeting held on July 18th be approved. Looking for a mover and a seconder. Moved by committee member Ladresse, seconded by committee member McMillan. All those in favor? That motion is carried. So we'll move to the new business. The first order of business, 6.11. It is recommended that the committee issue a certificate of cancellation as per application B1323 submitted by Heather Taylor and Martin Taylor for the lands legally described as Concession 10, Part Lot 7, RP 16R-4334, Part 3 and 4, in accordance with subsection 53, paragraph 45 of the Planning Act, RSO 1990, C-3, P-13, as amended, the Act. Looking for a mover and a seconder. Moved by committee member Colburn, seconded by committee member Glenn. Is there any discussion on this item? Okay. Seeing none, I'll call for the vote. All those in favor? And that motion is approved. So we'll move to item of business 6.1.2, a minor variance for Gary Quinton under section 45 of the Planning Act regarding property legally described as 125 Wilson Drive, Oxenden. I'll turn this over to the Secretary Treasurer.
Thank you, Mr. Chair. There have been no requests for deferral or withdrawal of the application. Notice of this minor variance hearing in accordance with Ontario Regulation 296 made under the Planning Act was given on July 19th, 2023 by ordinary mail to all property owners within 60 meters of the property, which is subject to the application, and to all the required agencies. Notice was also posted on the subject lands and the township's website. If you wish to be notified of the decision of the Committee of Adjustment, you must make a written request to the Secretary Treasurer of the Committee. Only a person or public body that requests a notice of decision of the Committee in respect to this proposed minor variance may submit an appeal.
Thank you. Could the planner give us a planning report regarding this file?
Thank you, Mr. Chair. Minor variance application A0523 seeks relief from the municipality zoning bylaw with a couple of provisions. The application actually proposes an addition to an existing cottage that's located on the subject lands, as well as the construction of a new detached garage. So to accommodate all of that, the applicant is seeking permission to vary the section 10.4 of the zoning bylaw, which is the shoreline residential section, to reduce the required interior side yard setback from 3.0 meters to 1.25 meters to recognize the existing cottage and allow the addition on that cottage. They're also looking to reduce section 10.4 for the required front yard setback from 7.5 meters to 5 meters to permit the accessory structure of the garage, as well as looking to reduce section 5.1, which deals with accessory structures, to reduce the interior side yard setback from 2.0 meters to 0.5 meters to help permit the garage as well. So I know there's a lot of variances there. There's essentially two variances associated with the garage. That's the reduction of the front yard setback and the side yards to allow for the garage. And the third variance is to recognize that the existing cottage is only set back 1.25 meters as opposed to 3 meters as permitted in the zoning bylaw. With minor variances, there are 4 tests set out in section 45 of the Planning Act. The variance must be minor in nature. It must be appropriate and desirable use for the lands, building and structure. It must maintain the general intent and purpose of the official plan, and it must maintain the general purpose and intent of the zoning bylaw. And through our review of the application, it's met all 4 tests. And therefore, we're recommending that variance application A0523 be approved by the Committee of Adjustment.
Thank you. I now call upon members of the public who wish to make a comment on this application. Please state your first and last name for the record prior to beginning. Seeing none, I don't see any people on the joining us virtually with any comments. So I'll just ask one more time for any public who would wish to make a comment. Okay. Are there any points raised by the applicant, committee, or public that anyone wishes to reply to? Yes, Committee Member Colburn.
Thank you, Chair Thompson. This is I guess my question is in regard to the reduced setback for the side yard for the garage. That seems awfully close to the neighboring property, and I'm just wondering, so that's 0.5 meter. Normally, we would, I think, look to ensure that proper maintenance can be done on the other side of a building. I just want to be sure that we haven't received any concerns from the neighboring property owner, and do we know for sure if that notice was received by that individual?
Yeah, I'll turn it over to our planner.
Thank you, Mr. Chair, and through you to Member Colburn. I actually did meet on site with the property owner, and although I didn't have discussions with the neighbor this would be the neighbor to the west of the property. That neighbor was actually at one point almost interested in doing a joint garage, so almost like a garage condominium, I suppose you would call that. But they're very much in favor of the Mr. Quinton's request for the garage. And when you're on site, you can see that the conditions are such that Mr. Quinton can get around to that side of his garage. That will only be 0.5 meter off the property line. There's lots of room there for maneuverability, and the neighbors, I think if they did do a garage, would do something similar where there was still, so the 2 garages wouldn't be close to each other. The way their lot is configured, they would put a garage in the same configuration as this garage would be.
Thank you. I noticed that is that answer your question, Committee Member Coburn? Yeah. I noticed that in my script, we didn't have an opportunity for the applicant to speak. Is the applicant here or do they wish to speak? Or maybe it wasn't because, yes, go ahead.
I did have a discussion with Mr. Quinton, the applicant, a couple days ago. He is actually today having knee surgery.
Okay.
So he was going to try to dial in if he was capable of.
Okay.
And I don't see him, so I think
Okay.
I'm sure, so, you know, having the effects of the surgery still.
Okay. Okay. Any other comments or questions by other committee members? Okay, seeing nothing, I'll now call for a vote on the motion and the decision. The recommendation is that minor variance application A0523 seeking relief to section 5.1 to reduce the required interior side yard setback from 2 meters to 0.5 meter to permit a detached accessory structure, and relief from section 10.4 to reduce the required interior side yard setback from 3 meters to 1.25 meters to permit an addition to the existing dwelling, and relief from section 10.4 to reduce the required front yard setback from 7.5 meters to 5 meters to permit the accessory structure satisfies the 4 tests of a minor variance as required by the Planning Act RSO 1990 CP 13. It is recommended that the application A0523 be approved. Looking for a mover and a seconder. Moved by Committee Member Glenn, seconded by Committee Member McMillan. All those in favor? That motion is carried. So we'll move to 6.1.3, a consent for B. Oh, you need to adjourn that. I'm going to ask for a mover that this public meeting be adjourned. Moved by Committee Member Glenn, seconded by Committee Member Ladresse. All those in favor? That motion's carried. So now I'll move to severance B1023 this is a meeting of the Committee of Adjustment to consider the application for severance for Brian Goff. Thank you. Under Section 53 of the Planning Act regarding property located at Concession 1, Part Lot 11, West Part Lot 10, Sarawak Township. Mr. Secretary Treasurer, please go ahead with your review.
Thank you, Mr. Chair. There has been a request to defer this application. It is recommended that application B1023 for Brian Goff, be deferred to a future hearing to allow commenting agencies additional time to provide relevant comments.
Thank you, Mr. Secretary Chair. I'll now call for a vote on the recommendation to defer. The recommendation is that applications B10 for B1023 for Brian Goff be deferred to a future hearing, affording commenting agencies additional time to provide relevant comments. Looking for a mover and a seconder. Moved by Committee Member McMillan, seconded by Committee Member Ladresse. Is there any further discussion? All right, I'll call the vote. Oh, sorry, all in favor? Motion is approved. I'll now call for an adjournment of this hearing. Looking for a mover and a seconder. Moved by Committee Member Coburn, seconded by Committee Member McMillan. All those in favor? That motion is carried. I'm moving to a consent. This is a meeting of the Committee of Adjustment to consider the application for consent for Larry and Darlene Miller under Section 53 of the Planning Act regarding property located at 217 Shepherd Lake Road. Mr. Secretary Treasurer, please go ahead with your review.
Thank you, Mr. Chair. There have been no requests for deferral or withdrawal of the application. Notice of this consent in accordance with Ontario Regulation 19796, made under the Planning Act, was given on July 20th, 2023, by ordinary mail to all property owners within 60 meters of the property, which is subject to the application, and to all the required agencies. Notice was also posted on the subject lands and the township's website. If you wish to be notified of the decision of the Committee of Adjustment, you must make a written request to the Secretary Treasurer of the committee. Only a person or public body that requests a notice of decision of the committee in respect to this proposed consent may submit an appeal.
Thank you. Could the planner give us a summary of the planning report regarding this file?
Thank you, Mr. Chair. The application was actually handled by Mr. Joy from JL Richards, and he is in attendance this afternoon and can speak to the application.
Thank you.
Through you, Mr. Chair, my name is Connor Joy. Like Michael said, I'm a planner that works for JL Richards, consultant planner. The application before you is B-11-23. This application is consent for the Shepherd property at 217 Shepherd Lake Road, specifically a lot line adjustment. The purpose of the application is to have the owner's residence located on the severed lot, which would be 2.7 hectares, and the remaining, or the retained lot, the remaining portion would be located on 26.5 hectare lot. The goal of this would be eventually merged with the abutting property, which is about 36 hectares. And the size was also owned by the same owner. The main purpose of this is, as the application or the applicant has stated, is for the purpose of estate planning. We have reviewed the application and we have come to the decision that the application is consistent with the PPS, conforms with the Grey County and Township official plan, and follows the general intent purpose of the zoning bylaw, and therefore is recommended for approval under the conditions we have laid out. I will note that quite recently this afternoon, Michael and the applicant and also Dave Wellwood from JL Richards, we had a call to discuss the conditions. They have been changed slightly. I'm not sure if the committee has a chance to review those conditions, but we would suggest it would be ideal to read them out here in the meeting to ensure members understand what the conditions of consent that we are proposing for this application.
Thank you, Mr. Planner. I do have the conditions here and I will read them. If it suits, I'll read them with the recommendation. So if that's the end of your report, then I'll move to the applicant. Hearing no objection. So I'll now call upon the applicant. I see that Mr. Davidson's prepared, so I'll stop talking and let you start talking.
Thank you, Mr. Chair, committee members. So my name is Ron Davidson, planning consultant. I represent the owners Larry and Darlene Miller. They are away on vacation and could not attend tonight's meeting. The application is really straightforward. It is not a new lot that's being created. It's simply a lot line adjustment or a lot addition, call it whatever you would like. Larry and his wife own a parcel of land upon which their house is located, and a couple of other buildings, a swimming pool, quite a nice property, and it's accessed from the private road known as Shepherd Road. And they want to give up some of that land, so they end up with a smaller piece of property themselves with their house on it. The land that they're going to give up will be attached to a much larger holding that fronts onto a different township road. So it's very straightforward application. Just a couple of things I would like to speak to the conditions. And as you just heard, there was some discussion this afternoon with the consultants and Michael and myself, and I do appreciate their time because we had that meeting about 4 o'clock this afternoon, so it's kind of urgent. I just wanted to talk about a couple of things, and we did. So one of the conditions talks about a minor variance for the property to reflect the fact that the lot that's the parcel that Larry and Darlene are keeping, it doesn't have any frontage along a public road, and it doesn't. It fronts onto a private road. And condition number, well, it was 7 in the report. I don't know what number, it might be 6 now. It states that the applicant apply for and have approved with all levels of appeals exhausted a minor variance application for the property, which accounts for 0 frontage situation present on the subject land, severed lands, pardon me, to be in compliance with the township zoning bylaw. So that minor variance would reflect the fact that the property currently doesn't have frontage on a public road. But that's not changing. And I just draw to your attention a comment that was made in page 8 of the planning report on behalf of the township. It just states that this is under the zoning section. Subject lands have zero frontage on a public road prior to this consent application. This non-complying situation is not changing as a result of the lot line adjustment. A minor variance application to bring the severed parcel into compliance with the bylaw could be included as a condition of consent should the committee view this to be appropriate. So this is pretty clear that the planner is suggesting that the committee give this some consideration. I mean, nothing's changing is my thought on that. We would have applied for a minor variance if we had known that that was going to be required, and you would have dealt with it tonight along with this consent application. So I know we got a couple of planners that are on the committee of adjustments. Maybe they have their own opinion, and that's no disrespect to the non-planners that sit on the committee of adjustment, but just something to consider. The other matter is the requirement for an archaeological assessment or to deal with Saugeen Ojibwe Nation. As I said earlier to the planners that met with me at 4 o'clock, I understand the Saugeen Ojibwe's certain their position in terms of getting an archaeological assessment whenever they can, and I deal a lot with them. In this particular case, it is kind of I guess a tough pill to swallow. Nothing is changing. This severance is not leading to any new development. And to require Larry and Darlene to get an assessment on the property, and that property would be the part that has their house, 2 accessory buildings or 3 accessory buildings, a pool, large parking area, and a driveway. Again, I understand why Saugeen Ojibwe makes that comment, but to ask the owner to pay $8,000 to $10,000 and to have a study done, likely not this year but next year, because I tried to hire an archaeologist yesterday and it's too late. It just seems like a lot of effort to apply to a property that's likely nothing's ever going to happen to again because it's already developed. Just food for thought for the committee, and I'll sit down and stop talking. Thank you, Mr. Chair and committee members.
Thank you, Mr. Planner. Mr. Davidson. I will now call upon any members of the public who may wish to make a comment on this application. Please state your first and last name prior to beginning. Mr. Mike Murray has registered with the clerk to provide comments in support of the application. Mr. Murray, I see that you're there. Are you prepared to go ahead?
Yeah, I am here. You can hear me okay?
We can hear you perfectly.
Okay, perfect. Yeah, I live at 153 Shepherd Lake Road, which is the first house down by the water. So it's the triangle property there that you may see on the map. And Larry and I, we do have obviously a neighborhood relationship. And I don't know, I just find it strange that there is a right of way that cuts up behind my house, my property that is on my deed, that runs behind all the other cottages and lots to Larry's house, which I guess was set up quite a few years ago to the previous property owner so they could access a cabin that used to reside back there because the road did not go all the way back. So, I mean, I had some concerns. I have spoke to Larry. I don't have, they're not major concerns. I just find it, I guess, a little bit difficult and concerning that none of this is even mentioned in this. Well, I'm just looking at the conditions now. And I did talk to Larry about potentially releasing that because I don't really understand, like it's not really required anymore. If Larry's house has access from the main, the main Shepherd Lake Road, and these other lots now, should have access from concession too. I don't really know where we go from here, but I don't want to squash Larry's estate planning either, but something I think sort of needs to be brought up here on this.
Thank you, Mr. Murray. I think Mr. Davidson referred to my lack of planning expertise, so I won't jump in on top of someone who'll know how we should proceed better than me. I'm looking to our planner as I think you're processing. Oh, pardon me, Member Ledresse. If you'd like to comment now, you can go ahead. I think you might still be on mute. Maybe try now. Oh, we can hear you.
Okay, I just had a question for Mr. Murray. I'm just trying to figure out which house or property that he's at. Did you say 153 Shepherd Lake Road?
That is correct.
Okay, I'm just having a look on the GIS here. Okay. And you said there's a right of way that goes along your property?
Yeah, the right of way goes along the back of my property, and that actually another complete person goes along his property. And then if you look at the very bottom of the tip of Larry's south property, where it comes into a triangle point, that's where it enters Larry's property.
Okay, thank you. I'm just wondering if the right of way is not needed, if it could be removed. I'm not sure.
I think our planner is looking into that. Is there any other comments while we're waiting? Not to put you on the spot, Mr. Ben. Yes, go ahead.
Sorry, Mr. Chair, I'm just conferring with the author of the report and his team at JL Richards were frantically messaging back and forth.
Thank you.
Seeing how we can address this.
Okay, I can appreciate that. So, I mean, maybe we can at the same, committee member Ledresse, you have a question again.
Yeah, sorry, through you, the chair. In terms of the like the frontage, it's my understanding, I'm wondering if the other committee members could help me out with this. It's my understanding that all of the properties involved in a consent or a minor variance have to be in compliance. So if there is no frontage, would it not require a minor variance?
Mr. Davidson, you look like you're ready to weigh in.
I'll try that, and I'll try not to insult anybody. So the fact that the property currently does not front onto a public road and it legally predates the zoning bylaw, it would have a legal non-conforming status.
Through you, Mr. Chair. Yeah, that's how we understand it as well. I think if I can probably provide some detail of what we were thinking. I think usually in this instance, when you have minor variance, or sorry, not a minor variance, we have a consent application. Usually you can place conditions on the severed portion of a land, which is usually the portion that would be creating a new lot. I know technically we're not creating a new lot here because there's going to be a lot addition afterwards. I think, again, a bit of a technicality, but nevertheless, usually you place conditions on the severed portion of a lot, not the retained portion of the lot. In this case, I think it's the fact that, yes, this predates zoning bylaw. Yes, the existing situation is not changing. But I think we try to bring properties into compliance with the zoning bylaw whenever we have that chance. And I think this is the chance we have at this point to bring that there is no public road frontage for this property. Obviously, it is not in our intent and not our goal to have an undue burden placed on this application that, oh, now they need to seek a minor variance to have this consent application approved. But I think out of the public interest and out of anybody in the future who would potentially own this lot and any other future development, bringing the lot into compliance with the zoning bylaw and noting in the zoning bylaw itself that it is that it does not have any road frontage would be something of the township's interest to do. That is how we see it. Again, there's many planners in the room, and we can respect Ron's opinion as well. It's not not that I don't see it from his point of view, but I just have, or we just have staff have a different point of view on this point.
Thank you, Committee Member Glenn.
Thank you, Mr. Chairman. I would support the planners in the opportunity at this point to bring the property into compliance with the zoning bylaw through the minor variance and attaching that as a condition. The second point that has been raised around the requirement for an archaeological assessment as it relates to the property, I would be fine with that condition being removed, as there's no development being proposed that would change the status of any of the karst features that will be on the site. So I'd be happy with keeping one and taking the other route.
Thank you, Committee Member Glenn. I was going to wait and have the opportunity, but I too would support taking the archaeological requirement out of the conditions. But I'll look to other. We've raised that point. I'll look to other committee members. So we've got a couple things. on the table here. I think we're talking about the variance, and I think we're talking about the archaeological dig. And I think we should probably separate the two and have that conversation. And I think we have the right of way. So I'm looking at the planner. If you're ready to talk about the right of way, we can do that. If not, I wonder if you want us to move ahead with the other two conditions.
Thank you, Mr. Chair. I did confer with my colleagues on the right of way, and it not thinking for a moment the right of way doesn't exist, but it's not showing up on the mapping that we use to look at properties, and that it's not a public private right of way by any means. It'd be a private right of way between the Miller property and their neighbors. So we're not suggesting that it shouldn't be addressed, but I think that's a separate legal exercise that is outside of the purview of the Committee of Adjustment to look at that, because it doesn't have a direct impact on the severance itself.
Okay. Thank you, Mr. Planner. I see Committee Member Glenn, you have your hand up.
Thank you, Mr. Chairman. This is a question through to Mr. Murray or the planner. Is it an actual right-of-way or is it an easement? And is it an easement registered against a number of properties, or is it registered only against Mr. Murray's property and Mr. Miller's property?
Thank you, Mr. Murray.
Yeah. Well, all I know is it's on my deed, and in the survey that I was provided when I purchased the property, it is also part of that survey that I was given. And I've had a lawyer look into it back in 2010, and he was able to locate all this information. So it's a little bit concerning that I guess the township doesn't have the same info.
Through you, Mr. Chairman, to Mr. Murray, it's probably not showing our info because it's an easement granted over properties for certain purposes. It's not a road right of way that the municipality would show on any of their documentation. Many easements are registered on properties to grant additional properties or adjoining properties access to them that the municipalities wouldn't be aware of.
Thank you, Committee Member Glenn. Committee Member Coburn.
Thank you, Chair Thompson. So I believe we're being asked to defer this until we hear from all consulting agencies. So I'm just wondering if some of these questions can be brought back to us once, like we're asking for a deferral for this one. Is that correct? I don't know. Do we need to make decisions on things?
I don't think we are.
Oh, okay. I'm misunderstanding that then. So in that case, which agency or agencies are requesting the archaeological assessment?
Through you, Mr. Chair, it was our understanding that SON had requested the archaeological assessment. I talked to Dr. Martin last week over the phone about it, and that's what he had indicated, that it would be best. I think, I'm not sure if they're in front of you, but this afternoon we had amended that condition specifically to place less burden on the applicant about completing the archaeological phase 1 and potentially phase 2, and having more discussion with SON about whether or not it was required, and then if they deemed to be required to have those studies done. So I would suggest maybe we read that out, or I can read it out just so then committee members are aware.
Thank you. That's helpful clarification. I'm not inclined necessarily to waive that condition at this time until we, perhaps staff have had the opportunity to speak with SON to get their perspective on whether that's considered necessary or not.
Through you, Mr. Chair, I think staff, like, taking on the information and the advice given from Dr. Martin, like, deem it to be at some point necessary. I think at this point the wording of the condition is what staff have changed, which kind of then that impacts how much work the applicant has to potentially do. And I think the initial wording was heavy-handed and very black and white about, okay, X, Y, and Z needs to be done. The current condition on the consent application puts the onus on the applicant that should the application be approved in front of you with that condition, that it puts the onus on the applicant to then work with township staff afterwards to address what potential studies need to be completed.
So I'm not sure if I'm reading the amended conditions, because my conditions do seem to place the problem in the lap of the owner and the applicant.
Mr.
Banner.
Thank you, Mr. Chair. If you will indulge me, I'll read out that amended condition.
Okay.
So it's the condition addressing the archaeological work. The new condition would read that the owner shall address matters of archaeological interest relative to the Saugeen Ojibwe Nation. It is recommended that the applicant consult with SON to determine the appropriate consultation to undertake the assessment if required. So in wording it that way, it turns back into a discussion between the applicant and the Saugeen Ojibwe Nation as to what level of work needs to be done to address their SON's interest in the application. And then they would, in order to satisfy this condition, the municipality would require some sort of follow-up, a letter or an assessment if that's required, and a sign off by the Saugeen Ojibwe Nation.
So would this typically happen for a lot addition?
It's yes and no, I guess, to put it honestly, Mr. Chair. It's the location that triggers this. It's along shoreline of Shepherd Lake, and I think that is what triggered the concerns from the Saugeen Ojibwe Nation. If it were inland, say it was or in a more of a municipal environment, it likely would not have triggered that. I think it's the location that.
Okay, so if we have, it sounds like we have a bit of a mixed opinion about this particular condition. How do we resolve that from a committee standpoint? Sorry, Councillor Coburn.
I just wanted to say that I'm okay with the wording of the amended recommendation that our planner just read out to us. I think that gives some latitude. It doesn't sound as heavy-handed, and it allows for some negotiation between the property owner and or some discussion at least with staff and with SON.
Committee Member Glenn.
Thank you, Mr. Chairman. I too am satisfied with the revised condition. Provides some flexibility for the applicant to deal with SON.
Okay. So if we have some agreement about that, I think we have an explanation about the right of way. Now our conversation is about the minor variance. So am I to understand Councillor Coburn, do you have your hand up? Okay. The minor variance, it is a separate process from this, then it can't be done at the same time. And so then this is where and you didn't insult me, Mr. Davidson. It was a statement of fact. My planning expertise is you could fill a thimble with what I know. But what I am to understand is all of those properties will have this variance, I'm assuming, or will have it's the only entrance for most of I would assume all of these properties, except for maybe a couple with some frontage. So this is where you'll tell me I'm not, but there is no way to do that and this together.
Through you, Mr. Chair, as the applicant had stated, if we had discussed this or if this issue had been foreseen ahead of time, this potentially could have been addressed. But as it is a condition of consent, this would have to be done afterwards. As once this minor variance is satisfied, then the consent could be approved and the certificate could be given. So yes, unfortunately, they'd have to come back to committee. And to your other points, you are correct that this frontage situation is very similar for the remaining properties that are also located on Shepherd Lake Road. Unfortunately, or fortunately, depending on where you sit, this isn't the only time I've dealt with an application similar to this where there was a lack of road frontage, and it just happened to be that this owner wanted to do something, and so they had to have this addressed through a minor variance. Again, we, as a staff's opinion that we see now the development is going on, we see it fit to address it now and to have that compliance. And if there was any of the other lots along Shepherd Lake Road decided to either sever their lot or do development or XYZ, whatever, in accordance with the Planning Act, we would most likely, or we would pursue the same variance to have that in the zoning bylaw that this property now complies because it has zero frontage, whereas before it was legal non-conforming status or legal non-complying status.
So I think the answer is there's no way to do that in this. It's a separate application.
Correct.
Okay. So I hate when I'll just say this. I don't like it when the government bureaucracy of whatever ends up in hitting somebody twice to do the same thing. So is there a way, and maybe this isn't the place to have it. So if we're going to make the owners go through another process, is there a way for us to forgive the costs, or is that something that this committee talks about, or is that something that council talks about, or is that something that only I think? And I mean, you might not have answered all those questions, Mr. Ritter.
Thank you, Mr. Chair. It's my understanding that in order to waive the fees, staff would need direction from council, I believe,
Okay,
as part of our fees bylaw.
okay, I kind of figured. Okay, maybe I'm the only person that might feel that way. I wondered if this is something where we should have maybe stepped in to say this needs to happen rather than miss it and say, well, you'll have to come back and do this over again. But I'm overusing my latitude as chair. So have we resolved the conditions or conversation about the conditions to the satisfaction of the committee members? So seeing no opposition, I am not sure that I asked any members of the public, did I? I did? Okay. I don't think I got to the statement of their points raised by the planner, applicant, or public that the committee wishes to respond to. No, we've had our say, but I just want to go through the process too. Seeing none, I will now call for a motion on the decision. Brace yourself, this might take a minute here. It has been demonstrated that the proposed application is consistent with the PPS, conforms with the county official plan, and follows the general intent and purpose of the Township of Georgian Bluffs zoning bylaw. It is recommended that consent application B1123 be approved, subject to the following conditions: that a reference plan be completed and a copy filed with the municipal clerk, or an exemption from the reference plan be received from the land registry office. The reference plan should conform substantially to the sketch, Schedule A, filed with the application for consent. That pursuant to section 53, paragraph 42 of the Planning Act, the certificate of consent be affixed to the deed within 2 years of the giving of the notice of decision. Note, section 53, paragraph 43 of the Planning Act requires that the transaction approved by this consent must be carried out within 2 years of the issuance of the certificate, i.e. the stamping of the deed. 3, that the owners pays the applicable consent certification fee at the time of certification of the deeds. 4, that the payment of the balance of any outstanding taxes as of the date of certification of the transfer and deed with respect to the property that is subject to the application shall be made to the treasurer of the Township of Georgian Bluffs. 5, that retained lands be merged on title with the adjacent lands to the west, described as LT 34, Lot 34, Concession 2, NCD Keppel, except Part 5 and 6, 16R 7166, Georgian Bluffs, to ensure the parcel has road frontage and can be accessed sufficiently. That the applicant apply for and have approved, with all levels of appeals exhausted, a minor variance application for the property, which accounts for the zero frontage situation present on the severed lands, to be in compliance with the township's zoning bylaw. And 7, that the owner shall address matters of the archaeological interest relative to the Saugeen Ojibwe Nation. It is recommended that the applicant consult with the Saugeen Ojibwe Nation to determine the appropriate consultation to undertake the assessment if required. Looking for a mover and a seconder. Moved by committee member Glenn, seconded by committee member Colburn. Is there any further discussion? Seeing none, I'll now call the vote. All in favor? That motion is approved. I'll now call for an adjournment of this meeting. Moved by committee member Ladresse, seconded by committee member McMillan. All those in favor? That motion is carried. Thank you, Mr. Davidson. I'm going to move to item 6.1.5, consent for McConnell. This is a meeting of the Committee of Adjustment to consider the application for severance for Keith McConnell under Section 53 of the Planning Act regarding property located at 137-429 Concession 7 Road, being West Part Lot 7 and West Part Lot 8, Concession 2, Derby Township. Mr. Secretary Treasurer, please go ahead with your review.
Thank you, Mr. Chair. There has been a request to defer this application. It is recommended that application B0923 for Keith McConnell be deferred to a future hearing to allow commenting agencies additional time to provide relevant comments.
Thank you. I'll now call for a vote on the recommendation to defer. Sorry. Let me take a drink. Recommendation is that applications B09 for Keith McConnell be deferred to a future hearing, affording commenting agencies additional time to provide relevant comments. Looking for a mover and a seconder. Moved by committee member McMillan, seconded by committee member Ladresse. Is there any further discussion? Seeing none, I'll call the vote. Approved? All those in favor? That motion is approved. I'll now call for an adjournment. I'm going to do this in perfect. I'll now call for an adjournment of this hearing. Looking for a mover and a seconder. Moved by committee member Glenn, seconded by committee member Coburn. All those in favor? That motion is carried. This public hearing is now adjourned. So, seeing that we have no unfinished business, don't see anybody jumping in to stop me. The date of our next Committee of Adjustment will meet as regularly scheduled on September 19th, 2023 at 5 p.m. If there's no other business, I'll now call for an adjournment of this meeting. Looking for a mover and a seconder. Moved by committee member Glenn, seconded by committee member McMillan. All those in favor? That motion is carried. Thank you very much and have a good night, folks.